So, hello and welcome everyone. Today we are going to take a look at two rulings, and both of them are from Germany. We're going to focus on the first one, which it's a case where the court provided some further guidance on the issue of willingness on the side of the implementer. So it looked at the implementer's behavior and set up some further requirements of what the implementer should do when he gets confronted with a notification of infringement. This is the first case and the main part of our webinar today. And then at the end, I would also like to take a look at a pretty recent opinion of a German court in a case where we had a particularity in the terms that the European Commission also intervened in these proceedings. The court gave a preliminary opinion in this case, and there are some very interesting findings to discuss, and that's what I would like to do today at the second part of the presentation. So let's start with the first case. It's a case where we have InterDigital on the claimant side and Oppo on the defendant side. And this is a decision that was delivered by the District Court of Munich almost a year ago, but unfortunately the decision was published only recently, so that's why we are looking at it now. Here, this case is part of a much broader dispute. So it's not the only case that was pending between InterDigital and Oppo. We have seen also in the past decisions coming from different jurisdictions in this dispute. This was, let's say, the German part of this dispute, which, if we look at the chronology, started almost 10 years ago. So it was in October 2014 when InterDigital sent a first notification to Oppo, and the reaction of Oppo and the negotiations that followed were pretty slow, so not much happened for a rather long period of time. Oppo declared its preparedness to start negotiations only in January 2017, so almost 2 years after the first contact. And even after that, there was not much going on between the parties. So at some point at 2021, almost 7 years after the first contact, InterDigital started the litigation campaign against Oppo. And as we said, there were lawsuits filed in different jurisdictions, including the UK, India, and also the German case that we're going to discuss today. The German case was successful for InterDigital. The court delivered its decision in December 2023, and it was a positive decision in a sense that the court found in favor of InterDigital and also granted an injunction against Oppo, preventing further sales in Germany. Now, this was not enforced in the sense that the injunction was not enforced by InterDigital. Whether there was appeal is also not very clear, but what is clear is that this case will very unlikely move forward because since October 2024, the parties signed a settlement agreement which would end all pending litigation and most likely also including these proceedings here. So this case is not expected to go in the second instance and have further judgments on this in this regard. Now, if we look at the case itself, the court had to deal with basically two defenses that Oppo had raised here. It's on the one hand the front defense, which is the common case which we have usually in these ICP cases. And in these proceedings, there was also some discussion around the so-called proportionality defense, which Oppo raised. So it had two angles in its defense, the front defense and the proportionality defense. We're going to see in a moment that the court was not convinced by any of the Oppo's arguments and dismissed both the front defense and the proportionality defense. In general, of course, the front defense was the main part of the decision. So the proportionality was, let's say, a subsidiary defense, which was raised as well. The main part of the decision revolved around the front defense and the requirements that need to be fulfilled under the case law. So as usually here, the front defense was based on competition law. So the main line of argument here was to say that by filing the action, which could lead to an exclusion of Oppo's product from the market, InterDigital abused a market dominant position that it has. So this is the common line under which the front defense is being discussed in German case law, which goes back also to the Huawei ZTE judgment of the Court of Justice of the EU. So this is how the court also proceeded with the examination of the case. And it started by looking at whether InterDigital has a market dominant position, because this is the first requirement. And here the court said yes, that InterDigital holds a market dominant position, basically because the patent in suit is essential in a sense that it must necessarily be used for applying the standard. And the court also saw no indication that there is an equivalent technical alternative in the market. So the court said it's basically only InterDigital that can provide a license for this patent, which is necessarily used to apply the standard, so dominant position is given. However, the court found that InterDigital did not abuse its market dominant position in the present case, neither by filing nor by proceeding with the lawsuit. Because on the one hand, the court did not see any flaws or significant flaws on InterDigital's behavior, so it did not believe that InterDigital acted in a non-front manner. But basically, the court found that Oppo has been acting not sufficiently willing to obtain a license. And this is basically the main part of the analysis of the court. It referred to the behavior of Oppo and whether it was to be considered as a willing licensee or not here. Before doing that, the court looked very briefly at whether there had been a proper notification of infringement on InterDigital's side here at the beginning of the dispute, at the beginning of the communication between the parties. This is, of course, a requirement also under the Huawei ZTE, because this is something that the patent owner is required to do before launching proceedings. So here the court took a look at what InterDigital had done in the years when the negotiations between the parties or the discussions between the parties were ongoing, and was pretty clear by saying that InterDigital had made an adequate notification of infringement. Basically because InterDigital had provided Oppo with claim charts before the action was filed, and the claim charts were also including the patent in suit. So there was also a claim chart including the patent in suit. And in the eyes of the district court, this was sufficient. This was not particularly new here as a finding. The court referred to the Federal Court of Justice, to the case law of the Federal Court of Justice in Germany, especially the Sisvel-Hayer case, where the court had also taken the same view that sharing claim charts is sufficient usually for a notification of infringement. So after this was done, the court then turned to the behavior of Oppo. And here it applied the standard that we have seen in several cases in Germany after the Sisvel-Hayer decision of the Federal Court of Justice. It looked at these two elements, whether there was a clear and unambiguous declaration of willingness, so let's say more the formal part, and where the focus was placed particularly was whether there had been sufficient engagement in negotiations in a target-oriented manner. The second element was the main element which the court looked at here. The clear and unambiguous declaration was not a very big question or a very big issue in this decision. The court clarified here, especially regarding the second part, this target-oriented engagement in the negotiations, that willingness must be actually given and not just for appearance's sake. So this basically is looking at the behavior and saying that you have to not say only that you are willing, but also to act like someone who's willing to take a license. So again, these qualitative elements here. And what the court also said is that it needs to be continuous, meaning that it's not sufficient just to be willing after you receive the notification of infringement. You have to keep on being willing throughout the negotiations with the patent owner, because otherwise this doesn't work. So it's made this interpretation and followed here also as well the Federal Court of Justice that willingness must be continuous, must be there throughout the negotiations. Keep this one because we will also look at that later on the second part of the presentation. So what the court then did was to look at the behavior of Oppo, and then the assessment was made based on this standard here. So the court asked itself, what would a reasonable party that is interested in a successful negotiation outcome do in a specific stage of the negotiations to promote this goal, to promote a successful negotiation outcome, considering the specificalities of the individual case. So here what the court did basically was to look at the specific scenario here and make the assessment based on the actual behavior of the parties, making again clear that the assessment needs to be done on a case-by-case basis. So you have to always consider what the specific situation was, for example, what information was available to the implementer at what stage, what the implementer did with this information. All of this needs to be tailored to the specific case. And this is what the court actually did here, looking at three different elements of Oppo's behavior. A major part was the counter-offer or Oppo's counter-offers. So this was a major part of the assessment of the court. And this is interesting because in general terms, if you have a counter-offer, you could say that the counter-offer itself is an indication of willingness, because you make counter-offer, and by that you make clear that you are prepared to sign an agreement on these terms. So this would basically indicate a willingness. But what the court did here was to examine exactly when, for example, these counter-offers were made, and also on which terms these counter-offers were made. And so that, again, it tailored its analysis on the specific scenario here. Looking at the first counter-offer, and maybe here just for your background, there were several counter-offers made. InterDigital had made in total 8 offers throughout the negotiations before the trial and also during the trial, and Oppo had made 4 counter-offers. So here the court looked at the first of them, which responded to the first offer of InterDigital, and had a problem with the timing, first of all. So it found that it was made very late. Fortunately, we are not sure how much time did Oppo take in order to make the counteroffer, because this part was redacted in the judgment. But definitely concern here of the court, irrespective of the content of this agreement, was that it was basically not early enough. It was not soon enough after the offer was received that that Oppo made this counteroffer. So timing was a factor here which the court considered in this case to the detriment of Oppo. Then the court also looked at the counteroffer itself and said, well, the counteroffer also lacks sufficient explanation of the terms. And this was a point of concern, particularly in the present case, because Oppo's argument, or one of Oppo's argument, was that the offers of InterDigital were not sufficient in the sense that they did not include sufficient explanation of how the terms have been set up, especially how the rates have been calculated. So here the court, keeping that in mind, find that complaining now that on the one hand that InterDigital's offers are do not contain sufficient information, and on the other hand making a counteroffer which did not include sufficient explanations either, by doing that Oppo applied double standards. So the court was not satisfied by that here, that the counteroffer was made late, first of all, but then also did not include sufficient explanations, although Oppo had requested for that when it came to InterDigital's offers. Then there was another argument here Oppo basically saying that they did not have to take position, especially regarding the first 5 offers that InterDigital had made, because these first 5 offers were at least formally not complete. So they did not include all provisions which are necessary to be included in a license agreement. So in the eyes of Oppo, an argument also maybe to explain the delayed response was that they didn't have to react at all to the offers because it wasn't really a full offer, a full-blown offer. So here the court was not convinced by that either, and it said there is only one case where you do not need to react to an offer received, and this is only when the offer is evidently non-front. What does this mean? The court here seems to apply a very high threshold by saying that an offer that's evidently not front is an offer which, from an objective viewpoint, is so far out of anything that could be considered front that you could say that it's not seriously meant. So it's not a real offer at all. And this was the threshold where you can exceptionally say that if you receive such an offer as an implementer, you don't need to engage in negotiations because it wouldn't make sense factually. It wouldn't lead to a front agreement. But the court clarified that apart from this one exception, there is an obligation to react to the offers, even if they're not perfectly front. And in the present case, the court also confirmed that Oppo had such an obligation because it did not find that any of the offers of InterDigital were not seriously meant. So they were maybe not perfect, but they were not to that extent evidently not front that they would not have required a response or a reaction on Oppo's side. The court then added here, again looking very much at the specific behavior here, at how Oppo had acted, that it is a bit inconsistent for Oppo to argue that none of these 5 first offers of InterDigital was actually an offer, while at the same time making a counter offer before they received the 6th offer of InterDigital. So here the court pointed out again at an inconsistency in Oppo's pleading, because on the one hand, they had been saying that they hadn't really received an offer, at least when it came to the first 5 offers they had received. But on the other hand, they had made a counter offer to one of these first 5 offers. So here the court again highlighted this inconsistency in the pleadings and the arguments of Oppo as a sign of unwillingness again. Then the court looked at the proceedings and how the proceedings evolved and focused on one specific element there, meaning that at some point in the proceedings, the court made very clear to Oppo that in its assessment, the front defense will be dismissed. So it made clear, it gave this indication to Oppo in the proceedings, during the proceedings, that it does not believe the front defense has merit. And the court expected then that this would trigger maybe an improved counteroffer on Oppo's side, because this is something that you would expect from someone who wants to take a license. If you get the indication from the court that you will most likely lose, and one reason for that is that your counteroffers are not front, that you would do an improved counteroffer. And Oppo did not do that here. It did not make an improved counteroffer, although it was informed by the court that it is very likely that the front defense is going to be dismissed. What Oppo did instead was to refer to a ruling that was delivered in the meantime in the UK in the InterDigital versus Lenovo case. What happened in this case was that the court had set also the terms for a global license between InterDigital and Lenovo, based on one single agreement, more or less, between InterDigital and LG. And in this case, the court had also doubted very much that InterDigital had made front offers to Lenovo before these terms were settled. So apparently it was Oppo using that decision from the UK High Court in the German proceedings to say basically that it did not make a counter offer because the terms offered by InterDigital were not front anyhow, and this was not then confirmed by the High Court. The German court in Munich was critical with this argument. So it said basically, okay, you can follow that, you can make this argument, but it's not really having much significance for the German infringement trial. Why? First of all, because this ruling was not final at that point in time. So the UK High Court had decided only in first instance. And we know that indeed in the second instance, the ruling was changed in between InterDigital and Lenovo in the UK. And then the court also said that we cannot really use this judgment here because the third-party license that the UK court had used for the royalty determination in the UK was not directly comparable to Oppo. What is more, the court said the UK case law in general is not really much impactful in Germany, especially after Brexit, because on the one hand, the English courts do no longer apply European competition law, and this was the case here in the InterDigital Lenovo case in the UK. The High Court had not applied, and because it's no longer bound to Article 102 of the TFEU. And of course, what the UK courts also do not do is to reference or to base their decisions on the case law of the German courts, of the German Federal Court of Justice. So that's why the court said here, this decision in general does not really mean much in the German proceedings, in the German context. But even if you would like to have, let's say, the counter argument, what it definitely does not suffice for is to justify why Oppo did not make another improved counter offer here. So that's also a finding of the court. And finally, the court was also not convinced by the counter offers of Oppo. It did not find that the offers were front. And here, basically, there was one point which the court highlighted, the fact that the terms were significantly lower than the terms agreed between InterDigital with other competitors of Oppo in the lower price segment, and the same, which also have the same geographical split of sales. So also in terms of content, the offers were not seen to be front because the terms offered were significantly lower than the competition, basically. So this was another reason why the court found that there was a lack of willingness on Oppo's side. So this was one element of Oppo's behavior, the counter offers and how it had acted towards InterDigital's offers. Then the court also looked at some of the reactions or comments of Oppo concerning the offers that InterDigital had made. And here Oppo had contested particularly two things. First of all, the royalty calculation and especially the royalty base that InterDigital had used in its offers. And it had also raised some concerns regarding an adjustment clause in these agreements. And the district court did not see any real issues here. So the first element was the royalty base. And here, Oppo insisted on applying an average selling price as a royalty base, which would be, however, based on the own products of Oppo, meaning not an industry-wide average selling price, but an average selling price of Oppo's products in the market. The court looked at the overall story again behind this case and found that in the specific case, it was too much in a sense that Oppo insisted on having this average selling price, its own average selling price applied here, and said that this is basically a further sign of unwillingness, that they are not prepared to accept the industry-wide average selling price. Why? Basically because Oppo had entered the market with products which are standard compliant and unlicensed without before seeking to take a license from InterDigital. The court said here whether you can use both the own ASP for your own products, or you can even use the industry-wide ASP for the calculation. Both is in principle acceptable. But if you want to use the own ASP, you need to have proactively sought a license at an early stage, especially before you enter the market. Because if you would enter the market without having taken any caution about who needs to be licensed and which licenses need to be taken, and then insisting that your own average selling price should be the basis for the royalty calculation, is a sign of unwillingness. The counter argument here was to say that yes, but if I use my the industry-wide ASP, it could be that I'm going to be discriminated against other competitors who are allowed to use their own ASP for the royalty calculation, because it might well be, especially if you have someone, an implementer who is doing business in the lower price segments of the market, that the average selling price, the industry average selling price, is higher than the own average selling price of the products. But the court said here, yes, this is a risk, but there is also a risk that you will have to pay the industry-wide ASP, and this would eventually also create discrimination. But this is a risk that you need to accept if you enter the market with unlicensed products. And this is something that cannot be corrected, let's say, afterwards by insisting to have your own ASP as the royalty base. So here the court saw clearly the risk of entering the market with unlicensed products without having done anything before in order to get and obtain the necessary license, as a risk that is clearly on the implementer's side. So it needs to be taken by the implementer. Then there was also some discussion about an adjustment clause. What do we mean here with an adjustment clause? It's basically a clause that would provide for changes in the royalties if there are changes in the portfolio during the duration of the agreement. And what Oppo asked here was that such a clause should be included in a license agreement, and contested that it had not been included in any of the offers that InterDigital had made. That's why the offers were not front. The court did not answer this question of whether you need an adjustment clause in an agreement in order for it to be front or not, because it said here this request or this complaint that you should have an adjustment clause in the agreement was not raised by Oppo at all before the trial, was raised only after the trial has started. And in the eyes of the court, without again saying anything about whether this was a complaint that had merits or not, this was something here that was just a proof of Oppo's tactically motivated behavior and the lack of willingness. So the court did not really address the question of should you have an adjustment clause in the agreement or not, but just said here the fact that you raised that at such a late point, only in the proceedings, and this was not anything that had been discussed before, shows that you are just doing that here in order to delay things, and this indicated in the eyes of the court again a lack of willingness on the side of Oppo. And then a final element of Oppo's behavior that was also taken into consideration by the court was referring to comparable licenses. There was a lot of discussion also in the proceedings about granting Oppo access to comparable licenses. Oppo had basically argued that they want to have access to all agreements that InterDigital has signed, all third-party licenses, by saying that they needed that not to delay things or to make things more difficult, but just to avoid being accused of cherry picking. So the argument here was we don't want to see only specific agreements, because then you could say that we want only to see the agreements that we think are better for us. Please provide us with all licenses, and then we can negotiate later on and see which are the agreements which are actually comparable to us. And what happened then in the proceedings, and that was also interesting, was the court asking Oppo whether after they have received access to all of these agreements, they would be prepared to sign an agreement on the conditions like the ones that would be extracted from the comparable licenses. And Oppo's answer to that to the court was no. So they didn't want to commit to sign an agreement. And this is what, at the end of the day, made the court find here that all of this discussion and these continuous requests to get access to all agreements were an impressive demonstration of how to hold out through this request for comparable licenses. So the court did not see that there was merits behind having access to all of these agreements, especially because even if you had access to all of these agreements, there was no guarantee that a license will be signed based on what you could extract out of these licenses. And what is more, the court just saw here nothing more than delaying tactics, not least because the court acknowledged here that the most of the licensees were already known to Oppo, so it could have filtered, in a sense, the comparable agreements already. But saying that you need access to all of the agreements and then not committing to sign a license on the terms that are comparable to you was seen as only a further justification of delay. So this was also an element which the court considered here to be an indication of unwillingness. And this is why, looking all of these aspects together, there was a clear finding that Oppo was not willing to take a license here, but rather wanted to delay things and to hold out. So this was the analysis of the court regarding the front defense. And then we had also this subsidiary, maybe, defense that Oppo had raised here, which was the proportionality defense. And here, basically, the argument behind that is to say that we have a product that applies many different technologies. We have here only one patent infringed. So if you would grant an injunction that would bar us from selling products totally from the German market, and this would be based only on the one patent, the value of this technology incorporated in this one patent is not proportional to the harm that could happen by granting an injunction. So that's why the injunction should be withheld here, should not be granted. So that was the main idea behind this proportionality defense. And this is also in the last 3 or 4 years after the reform of the German Patent Act, based on a respective statutory provision that is included in the German Patent Act now. So here the court needed to decide whether basically it would enter into a discussion regarding the proportionality defense or dismiss it, let's say, in principle. And the court seemed to favor the last option, because it said, as a rule, typically when you have a front defense in proceedings that can be raised on the merits, and meaning raised on the merits that it can be supported by facts, more or less, so not a successful front defense, meaning if you have the possibility to raise a front defense based on how the case has been set up, then regularly this proportionality defense would not be available in SEP cases. There is only one exception when extraordinary circumstances exist. The court did not describe now which would be these extraordinary circumstances, but it, in any case, did not see any of these type of extraordinary circumstances applicable to the present case. So at the end of the day, the court said, since you had here a front defense, you could raise a front defense, and you raised a front defense, In addition, a proportionality defense is not available. So you should not be able to raise that as well, in addition to front. And what is more, the court went even a step further and said here, well, an implementer who is being sued and is being found to be unwilling, but nevertheless raises a proportionality defense, acts in bad faith, meaning that this could, at the end of the day, be also another factor to consider with regards to the willingness of the implementer. It could mean that if you have someone in proceedings raising this defense, this could be a factor that could be regarded as, together with all the rest of the behavior, in the assessment of willingness. So here the court again made clear that the proportionality defense on top of the front defense is rather something difficult, it's rather something exceptional, and trying to use that maybe in a way that would make unwillingness even more stronger is something that the court here would not like to see. So this defense was at the end dismissed as well.